Your thoughts on, some of all of these things that I've unpacked before, we discuss on the issue of Nnamdi Kanu as well, because I believe that he has also filed.
Yes, very complex issues. And I think in this instance, I always like to say two things can be true at the same time. Mm-hmm. The first issue is dealing with the incarceration of the lawyer and the other group of activists. Now, when you look at that FIR report and the issues that they are being indicted for, there are a number of concerns. The number one concern being people are saying that, but this group also included Showore himself, but Showore is a free man, and the other 13, I believe, are in prison. So why is there separation between those who have been arrested? If they were all together in a group and alleged to have all committed the same offense, why is there this selectivity? So that means that clearly the playing field is not level. The rules are not applying equal.
The detained leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, made a dramatic turn on Tuesday by agreeing to enter his own defense. Kanu informed the court that he will present a total of 23 witnesses divided into two categories. The first category, he said, will be those he called ordinary but material witnesses. Then the second category of witnesses will be vital and compellable and shall be summoned under Section 232 of the Evidence Act 2011. Among those Kanu listed as witnesses are the former Minister of Defense, General Theophilus Danjuma, retired, the former Chief of Army Staff, General Tukul Buratai, retired, Babajide Sanwo-Olu, Governor of Lagos State, Hope Uzodinma, the Governor of Imo State, and others. Please like and subscribe to this great channel for more breaking stories. Drop your opinion regarding the story in the comment section and drive the conversation.
Barely 24 hours after the protest, the detained IPOB leader, Nnamdi Kanu, in a motion he personally filed on Tuesday, October 21st, agreed to enter his defense and informed the Federal High Court of his plan to call a total of 23 witnesses divided into two categories. Well, among those listed as compellable witnesses are former Minister of Defense, General Theophilus Danjuma, former Chief of Army Staff, General Tukul Buratai, FCT Minister Nyesom Wike, Works Minister Debu Mahi, Governor Babajide Sanwo-Olu of Lagos State, and Governor Hope Uzodinma of Imo State. The detained IPOB leader told the court he would testify on his own behalf, providing a sworn account of the facts, denying the allegations, and explaining the political context of his statements and actions. He requested a 90-day time frame to conclude his defense, given the number of witnesses. I mean, Rufai, what a dramatic turn of events. Kanu's lawyer has been remanded in Kuje Correctional Center for participating in the protest. The timing and Kanu's decision to personally sign the notice raised questions about his relationship with his legal team and suggest a significant strategic pivot in his defense approach, potentially signaling his readiness to confront, the charges directly after years of legal challenge. People would say, he had no choice. Right now, his lead counsel is in detention. He has to, I believe he also is a lawyer, he says, Nnamdi Kanu. I've said some places that he said that.
You see, if we want to build a nation, let's build a nation. If we want to be hypocritical, let's be hypocritical. For all of those that are saying Ejimako has no right of protest, and I'm not a lawyer, so please, you can challenge some of my thoughts, but I'll think freely on this. And they are claiming sub judice. We have all been on this table where many cases that are currently in courts have been come to discuss here. Do you remember? Can we even go back and point out a couple of things? Anyway, we remember the debacle of Natasha, and we remember how people were coming to discuss the case while even the judges said they shouldn't discuss it here. Do we remember? Why didn't the legal disciplinary committee, why were they called in then? This case it's been on for a while. You remember that at some point during President Buhari's administration, some Igbo leaders, even when the case was in court, went to prevail over President Buhari for a political solution. Were they sub judice then? I'm talking about those Igbo leaders.
Yeah.
Recently, we've heard that governors like Alex Oti and a couple of other governors, I think governor of Imo State, have been talking to the president about a case currently in courts. Can we also deem those as sub judice? So please, I don't know anything in law, but I just think out loud. So please, you can educate me. I'm open to education.
We will learn more.
No. So I want to learn.
A huge debate.
No. And that's why I'm asking. And I've cited my position that were these engagements sub judice, the one that the great elder statesman from the South is that even finally passed after that negotiation with President Buhari at an early, was a former federal minister in the 60s in this country. They went to President Buhari to ask and beg that Nnamdi Kanu should be released political solution. The governors that have been talking to the president as regards that, are these also sub judice? Because when you say, okay, Ejimako went to protest about a case in court and you say, okay, sub judice, you should know better. Now he's been detained and, he's been taken against his right. We forget he's a citizen first. Well, those other instances were they sub judice. That's just what I want to. And please, let's also put a background on this case. We've also had a court in this country that have said Nnamdi Kanu did no wrong and should be discharged and acquitted, and appeal courts, before this case had been taken to the Supreme Court. So let's also put that in the context of this conversation.
Right.
When Nnamdi Kanu says he wants to go ahead with his defense process, yes, he has a right, but also it's only incumbent on let's even make a verification if he was the one that listed these people out. And let's make a verification on that process that was said that came from him, and let him go through his defense. A man has a right to be able to defend himself.
Right.
I am not saying that we should not, have a definitive stance on the rule of law in this country. But all I point out every day is the hypocrisy.
The selective application.
I mean, there are people now that we see them carrying guns and everything, bandits, having peace meetings and all that. Nobody have arrested them now. Okay. Their matter is not in court, it's not sub judice now.
All right.
So that one is out there. Then secondly, we have also seen people that were pardoned, bandits, criminals that were pardoned. All we're also saying is the political solution that you feel was good for the bandits that people speak for, give it to this man and charge him that if any other thing is done again, then actions will be meted out. That's all what a lot of people are calling for in this regard.
Yes.
That's just it. So if you call him all sorts of things, you call him a terrorist and everything, but you've done it for some bandits in the past now, why is it so different?
All right.
That's all I'm asking. All right. I'm not saying I support the way he went about it. I'm not saying I support all his abuses.
All right.
You did the same process people are saying do for this man, for other people that we saw. You even rehabilitated them. Like Dr. Bati said, you give them ashwebi and jollof rice and pepper soup. These are people that carry gun. No? I'm not sure Nnamdi Kanu ever. Did you ever say any gun is not going to shoot people? But these are even people that carry gun. No, that kill
criminals.
That criminals that committed heinous crimes. So
all right.
You gave them a waiver and you said they should be good members of society again. All we are just saying is for the sake of balancing and for the sake of let's have fairness.
All right.
Let that same thing be done to Nnamdi Kanu, and let's also charge him that all the insecurity there that people attributed to you, let it stop.
All right.
So that at least when Nnamdi Kanu is out of the picture, anybody that does this thing again, we say, okay, we know this is criminality. That's all I'm arguing.
The names that he mentioned, though, as compellable witnesses, I mean, I wonder how that will play into his, defense and all of that. He's asking for 90 days. I believe the last time there was a ruling by James Judge Omotosho, he had said that Nnamdi Kanu should, conduct his case within 6 days. So I don't know. I mean, he's now asked for 90 days. It seems like another extension.
In another development relating to the recent protest demanding the release of Kanu, the Center Against Injustice and Domestic Violence has called on the Nigerian Bar Association to take disciplinary action against Aloy Ejimako for participating in the protest, describing it as professional misconduct. Please like and subscribe to this channel. Stay glued to listen to the story to the end. and drop your opinions regarding the issue in the comment section below.
Good morning to you, viewers. Let's begin what's trending with an update to the Free Nnamdi Kanu protest on Monday, where despite court orders, protesters led by activist Omoyele Sowore trooped out to demand the release of the leader of the indigenous peoples of Biafra. Well, on Tuesday, a magistrate court ordered the remand of Aloy Ejimako, one of the lawyers representing Nnamdi Kanu, in Kuje prison. The police arrested Ejimako after he joined protesters demanding Kanu's release and charged him alongside 12 others with various offenses, including criminal conspiracy, disobedience of a lawful order, inciting disturbance, and disturbance of public peace, contravening sections 152, 114, and 113 of the Penal Code law. This development has escalated the controversy surrounding the protest, while legal observers note that while lawyers have the constitutional right to peaceful assembly, their arrests during the protest they participated in adds another layer of complexity to an already contentious case involving freedom of expression, the right to protest, and due process. Well, activist Omoyele Sowore, in response to this detention, actually put out a post on X, and he wrote, "It is unfortunate that the Nigerian Bar Association has remained quiet regarding the unwarranted and unjust detention of Nnamdi Kanu's lawyers, Aloy Ejimako and Barrister Okereke Kingdom Nnamdi. President Afam Osigwe, what is going on? Hashtag Free Nnamdi Kanu now." In the meantime, the Center Against Injustice and Domestic Violence has called on the Nigerian Bar Association to take immediate disciplinary action against Aloy Ejimako for alleged professional misconduct. In a statement, the group condemned the lawyer's appearance at the protest ground, describing it as a clear breach of professional ethics and a violation of Rule 33 of the Rules of Professional Conduct for Legal Practitioners 2023, which deals with sub judice statements. And according to the rule, and I'll read this statement in part, it says, a lawyer or law firm engaged in or associated with prosecution or defense of a criminal matter shall not, while litigation is pending, make or participate in making any extrajudicial statement that is calculated to prejudice or interfere with the fair trial of the matter, adding that the law expects that lawyers argue their cases in court, not on the streets, in protest grounds, or on media platforms. I mean, Vimba, I'm coming to you. Mr. Ejimako's participation in this protest is, they say, is tantamount to trying to sway public opinion and, by extension, the court's view on the matter still under adjudication. I mean, your thoughts on, some of all of these things that I've unpacked before, we discuss on the issue of Nnamdi Kanu as well, because I believe that he has also filed.
Yes, very complex issues. And I think in this instance, I always like to say two things can be true at the same time. The first issue is dealing with the incarceration of the lawyer and the other group of activists. Now, when you look at that FIR report and the issues that they are being indicted for, there are a number of concerns. The number one concern being people are saying that, but this group also included Sowore himself, but Sowore is a free man, and the other 13, I believe, are in prison. So why is there separation between those who have been arrested? If they were all together in a group and alleged to have all committed the same offense, why is there this selectivity? So that means that clearly the playing field is not level. The rules are not applying equally, and many people are even challenging and contesting those rules to say, well, is this really what transpired? Were they really causing public disruption with their protest? Besides the fact that they did stay within the limits prescribed to them, when they tried to go beyond those limits, the police acted, and they were peaceful in their execution. However, another issue that I brought up earlier that I'll bring up is this issue of chanting war songs. And I think we have to be careful now with where we're going. I drew parallels with the case of Julius Malema in South Africa, who was taken to court over chanting a war song. If you remember, he has a song called Kill the Boer. And he says that it's not an insightful song because it's a remnant of their liberation past. So we now need to start having a conversation in Nigeria about whether chanting of war songs that are remnants of a struggle of the past do constitute a public disruption in some form or the other. In South Africa, it was ruled to have been within the constitutional right of any activist or advocate to chant any war song they want. Now it's set for the Nigerian law to set their own precedent on this issue. Now that's on one aspect. On the aspect of sub judice, the rules are clear. This man was on the streets advocating for and vocalizing for a case that should have been in defense as of that point. Of course, we've seen a number of issues that have come up with regards to delaying going into that defense. But at this time, I think that we need to focus our attention to the defense because the prosecution have rested their case, and it's now up to Nnamdi Kanu to put forward his own defense. I know there are other developments that you'll come to, but and it's now not only is it up to him to put forward his defense, but it's also up to the public, civil society, to hold the judiciary accountable to ensure that his defense is treated fairly, it's given in a fair environment, and that he has access to all that he needs to be in order for him to provide a thorough and robust defense for himself. I think I hope I've dealt with many of the substantive issues, but yeah.
I mean, in terms of Ejimako being, detained in Kuje and all of that, you would wonder, I mean, he's a lawyer, shouldn't he have known the rules? But I'm sure that there'll be other, lawyers that would actually come and argue his case as well as to whether or not he had a right to protest at the same time. But meanwhile,
also, in the Senate, it was another drama where Senator Oshiomhole, during plenary, asked the Senate President Godswill Akpabio not to allow Senator Natasha Akpoti-Uduaghan to reintroduce a matter that has been treated in the Senate.
Let's now turn to the Nigerian Senate, where a heated clash occurred on Tuesday, October 21st, between Senate President Godswill Akpabio, Senator Oshiomhole, and Senator Natasha Akpoti-Uduaghan regarding a controversial abortion clause in the Criminal Code Act Amendment Bill 2025, which aims to strengthen laws against sexual offenses, including prescribing life imprisonment for child defilement. The dispute arose shortly after the Senate voted to step down the bill for further deliberation. Senator Akpoti-Uduaghan attempted to reopen discussion on a sensitive abortion-related clause, prompting immediate objection from Senator Oshiomhole, who raised the point of order, arguing that it was against parliamentary rules to revisit a matter that had already been concluded by the Senate. Let's take a look before we come back for a discussion.
Those in support say aye. Those against say nay. The ayes have it.
Mr. Senate President, please may I speak? I'm a woman, and abortion has to do with women. It's very important, sir.
Let us go to clause. This has been stepped down in totality. Distinguished Senator, this has been stepped down in view of the conviction, but if you have anything to add, you can say.
Thank you very much, sir. Senator Natasha Akpoti-Uduaghan, Kogi Central. Sir, this borders on abortion. And...
Yes, Senator.
Mr. President, we have been tutored over and over that when a matter has been concluded and you have dropped the gavel, in this particular case, to allow for more conversation, if you grant exemption to distinguish Senator Natasha, then you must extend the same extension to us, in which case our rules will become meaningless. I think the rules should be obeyed. We have said more discussion, which allow her to make any input, and I also intend to make more input. I think that is the whole essence of deferring it. To continue the debate, many of us will rather debate it here. So I think my distinguished sisters should agree that these are the rules.
I'm not a spirit to know what the senator wanted to say. The senator said, I want to say something. But If I knew, I would have referred her to Rule 52, sub 6.
All right, that section. Akpabio went on to rule her out of order, but I must say that he did show grace. But, you know, Natasha, being a woman, I believe, should have been given the floor to speak. I watched the proceedings and debate, and she appeared to have been calling to speak for minutes before that debate was closed. The bill was subsequently referred to the Senate Committee on Judiciary and Human Rights for further review. However, we're getting reports that women groups are planning to issue a statement to stop the review and demand a public hearing instead, objecting to the passage of the amendment. Now, when you look at some of the sections of the abortion clause in the Criminal Code Act, it appears quite controversial and confusing. I did look at it. For example, let's read that section 4 of the amendment of section 230 on supplying drugs or instrument to procure abortion. Section 230 of the Principal Act reads in part, any person who unlawfully supplies to or procures for any person anything whatever, knowing that it is intended to be unlawfully used to procure the miscarriage of a woman, whether she is or is not with child, is guilty of a felony and is liable to imprisonment for 5 years. I mean, this is such a huge debate. This debate highlights, the controversial nature of abortion legislation in Nigeria. Ayo, before I come to you, I'd like to take some reactions on X. But like I read in that section, the idea of miscarriage of a woman, I mean, that's, that also probably was what she was trying to debate. It's not miscarriage of a woman, it's miscarriage of a fetus. There is nobody that willingly wants to miscarry a child. It's an involuntary action, correct? But let me take some reactions on X. This person wrote, Senator Natasha has a valid point. Issues like abortion affect women directly, and her voice deserves to be heard. Silencing her only shows how male-dominated the system still is. Rule of order or not, the Senate should at least listen when a woman speaks on issues like this. Another ex-user wrote, abortion is not the only sensitive thing discussed in the House, but the rule must be followed. There is a channel everyone in the House can make points when a case has been closed. She was not silenced. The House was just reminded of the proper thing to do. Another ex-user wrote, we don't have many women in the National Assembly, and since it's a deliberation on a topic that concerns women, she should have been given the chance to air her views. Rule or no rule. Finally, an ex-user wrote, see men talking about abortion like they get pregnant. That was actually my favorite ex. But this is such a big topic. Yes. Worldwide, in the United States, senators get removed for, some controversial comments about abortion. But like I said in my opening statement, I believe that she should have been given the floor, even if it was for 30 seconds. Senate President Godswill Akpabio heard her and was about to give her the floor until Senator Oshiomhole intervene.
Okay, so what I want to interpret from that interaction is that Senator Oshiomhole is a stickler for rules, irrespective of what happens. But there's such a thing as discretion. And I believe that it is in the power of the Senate President to have discretion as to, okay, this matter, even though it's been stepped down, because of the nature of it and the fact that we have only 4 women in the Senate. Senator Natasha Akpoti-Uduaghan, Senator Ekpalibo Banigo, Senator Idi Atolunronti Adebole, and Senator Kinigbe. 4 of them. Out of the 4 of them, 1 woman has consistently had her voice, tried to have a voice in the Senate. I don't know why. I don't know where the other 3 senators are. Maybe we should also spotlight the fact that despite the fact that women are disproportionately not represented in the Senate, we don't even hear the voices of those who are represented. I like the fact that you noted that she had raised her hand earlier whilst the debates were still going on, and this is not the first time. We don't want to make it seem as if it's a victimization as a result of what had transpired prior. I don't want to say that that is what is happening. I don't want to believe that is what is happening, because that's a hallowed chambers. I want to imagine that they'll be very professional. Now, on a topic like this that involves women directly, at least one female voice ought to be heard.
I think one person spoke and backed the amendment, saying that it should be increased to 5 years. The felony punishment or the punishment should be increased to 5 years.
Yeah, but no, in terms of for the abortion conversation and nitty-gritty of it, I believe that what the Senate President did initially by using his discretion to say, okay, you know what, speak up, and then was in order.
I thought
we understand the rules, and people talk about rules and rules, but rules are made for the people and to enable a smooth running of the process. In extenuating circumstances like this, where you feel that the conversation will be made richer or be made robust and it's more inclusive, especially by the primary stakeholders, I thought that at least that discretion ought to have been extended to her. And this is also to make a bigger plea for ensuring that the voice of, this is not Senator Natasha Akpoti anymore. This is Kogi Central speaking. They must recognize that. Because when you silence the voice of one person, you're not just silencing her voice, you're silencing the voice of an entire constituent. You're silencing the voice of an entire demography, which is the women of Nigeria, whom only 4 of them out of 106 of them represent. So I think in that regard, that ought to have been done. That's so simple.
In all fairness, quick comment. I commend Senator Akpabio because he exercised that discretion in this regard.
He did very well.
It doesn't mean that if he does otherwise, I will not say it. I will say it. But on this, I commend Senator Akpabio. And I don't think Senator Oshiomhole should have just come in there. He just allowed the woman to speak.
That is it. But now the matter has been, pushed to a judicial review. Like I said, some women groups are trying
town hall. That's
what they're asking.
That's what they should have that.
Want a public debate. The matter should not be debated by only men and just 4 women and all of that. There should be a public debate and all of that. But we will follow up on the story. But also kudos to the senators for bringing these sort of sensitive issues to the floor of the House. Meanwhile,
considering the importance of issues surrounding women and abortion, do you think Natasha should have been allowed to reintroduce the matter? Or Senator Adams Oshiomhole was right to have asked the Senate President to stop her in compliance with the Senate standing rules? Please like and subscribe to this channel.